Welcome to the mock exam. Thank you for traveling so long with us. We at Chandu EduSphere, we try to provide you with a lot of model papers along with solved past papers, and a lot of you have used our resources, and I hope you find these things very useful. You find these papers very resourceful, uh, reflecting the actual exam as per the syllabus and the practices All India Bar exam has been dealt with so far in the last 20 exams. So upcoming is the 21st exam on June 7th, and I'm sure you are preparing for that exam, and I wish you all the best, and I'm sure you will find your practice very handy, very useful, and you'll be very comfortable in dealing with the real exam. Wish you all the best. Now let's move into this mock exam. Mock exam has 100 questions, and each question is identified by the area on the left side, left spine, and the subject as well as the area of the subject. And on the right side, you will find what past exam this question has appeared on. This question, for example, first question, by which Constitutional Amendment Act was the anti-defection law, within the brackets you see 10th schedule also added. See, the question itself is giving us a lot of information. So if you go to the bottom, the strategy, the 10th schedule, anti-defection, was inserted by the Constitutional Amendment Act, that is the 52nd Amendment Act in 1985. This is primarily to stop defection from one party to another party after elections. So the second question is, when an offense is bailable, when we deal with the bailable offenses, the accused has a right to be released on bail upon arrest. So getting bail becomes the right of the accused. So okay, how you deal with this? So this is primarily from CRPC. We can see that R Bharatiya Nagarika Suraksha Sanhita 2023. So we need to deal with bail is a matter of right, CRPC, according to 436. In the new law, it's section 478. In non-bailable offenses, bail is discretionary of the court, whereas in bailable cases, it is the right of the accused. So accordingly, we need to pick the section. Then, which order has been especially enacted to protect the interests of minors and persons of unsound mind in suits? So, Order 32. See, whenever we deal with the Code of Civil Procedure, we deal with the situation as well as the procedure to follow in the form of orders and rules. So, CPC Order 32nd, suits by or against minors and persons of unsound mind, maybe their guardians, their friends can deal with that. So party capacity orders sit in the 30s. So Order 31, trustees. Order 32, minors. So that's how we need to navigate ourselves to the right choice. Question number 4, the right to property. Obviously, this comes from either the constitutional articles or remotely related to Property Act, but really this is the right of an individual. So most probably from the constitutional law. Article 300A. A implies this came from some amendment. So constitutional law amendments deal with this type of things. Was inserted into the Constitution by which Amendment Act? The 44th Amendment Act. So what happened in the 44th Amendment Act in 1978, that we need to understand, and eventually, because this exam is an open book exam with bare acts, how to reach this particular article or section of an act, that becomes very critical. As we go through this paper, we will also identify the techniques how we actually start locating the particular sections or definitions in a particular act from the subject areas. As per section 2C Criminal Procedure Code of 1973, a cognizable offense is one where, in cases of cognizable offenses, a police officer may arrest without a warrant. Okay, we need to contrast this with non-cognizable at the same time. That way we can easily remember the related sections or the concepts around bailable as well as non-bailable, cognizable as well as non-cognizable. In cases of cognizable, a police officer can arrest, and he can also anybody for that matter, and even a private citizen can arrest, can get hold of the accused, the offender. Which of the following is not an essential element of a decree? Decrees are what you get from the proceedings of a court. An adjudication from which an appeal lies as an appeal from an order. So this can be appeal to. A decree is a formal expression of an adjudication conclusively determining rights given in a suit. An appeal lying as an appeal from an order indicates an order, not a decree. So how you navigate to this? Dissect section 2 of 2 into its 3 positive tests and matter. This is coming from CPC. This is a procedural matter, and we need to identify what comes out of it at the end of the procedure. Next question. Who among the following can claim the rights under Article 19 of the Constitution? A company, only citizens; a corporation, citizens and aliens. Only citizens can claim from Article 19, the rights under Article 19. Article 19, freedoms are available only to citizens and not to companies or foreigners. Contrast this with Article 14 and Article 21. They are available to any person. So, read each FR, fundamental rights, opening words. All citizens versus no person tells you the bearer. So, Article 19 is available only to citizens. Rajesh strikes Sunil with an iron rod, fracturing his arm, a fracture being grievous hurt. Which offense has Rajesh committed? Well, it's voluntarily causing grievous hurt under IPC 325 or BNS section 117. So naturally, somebody is hurt. We need to look into either IPC or its new form BNS, its replacement Bharatiya Nyaya Sanhita. So under those two acts, of course IPC is now replaced by BNS. Still, for continuity's sake, we have to deal with these sections. We need to understand what in IPC corresponds to what section of the BNS. So we need to figure out the area, the subject area, as well as probability of where we are likely to find an answer to the question. The next question. Which provision of the CRPC provides for a reference to the High Court? So it's obviously from CRPC or its replacement BNSS. So under that, the specific area we need to look for is reference and revision. Reference and revision, because from the lower courts, when you go to the higher courts, the lower court has to refer, or we will appeal to the higher court for a revision. So, where it is likely to be in CRPC, of course, chapter 30th, references and revision, section 395 deals with a reference to High Court, equivalent to BNSS section 438. A reference precedes revision, obviously, section 397 plus. Under CPC, a decree holder means any person in whose favor a decree has been passed or an order capable of execution has been made. Of the two civil parties, whoever wins the case, so to say, he gets a decree which can be executed. So CPC section 2(3). Note the inclusive limb. It covers an order capable of execution, not only a decree. So how we navigate that? Section 2 definitions paired with section 2 of 2 decree and section 2 of 10 judgment debtor. So all these are related concepts. Next question. Which provision says a confession made to a police officer shall not be proved against the accused? So because the accused may be coerced into some confession, so confessions are not admissible. Section 25 of Indian Evidence Act, and section 23 of the new Bharatiya Sakshya Adhiniyam, they both say that confessions obtained by police are not admissible in the court of law. So these are the related sections. So obviously confessions, this type of matters are dealt with in Indian Evidence Act or the corresponding new act, Bharatiya Sakshya Adhiniyam. Under the Indian Christian Marriage Act, the marriage registrar for a district is appointed by. Who appoints the marriage registrar? Each district has one of them. It's a state government as per the Christian Marriage Act. Indian Christian Marriage Act 1872. The state government appoints marriage registrars. How we go there, where we find this one? In appointing authority, check the Act's administrative machinery sections. So go to family law, then the Christian law, then we will find who appoints the marriage registrar. So the navigational cruise is a strategy that we need to follow to reach to that section where we find the correct answer. An agreement in restraint of marriage, an agreement to remain unmarried is who will agree for such a thing, and whether it is valid or not. It's void to start with. So under contracts, specific relief under property acts or all that particular section area or that particular subject area, in contracts we deal with types of contracts and whether they're valid or not, void or voidable, all sorts of things. So under void agreements, you find this one. Every agreement in restraint of marriage other than of minor is void. We cannot get into any agreements like that. Void agreements, section 24 to 30, restraint of marriage 26, those relevant sections we need to remember. What is the minimum number of judges who must sit to decide a case involving a substantial question of law as to the interpretation of the Constitution, the so-called constitutional benches అంటాం కదా, Article 145(3) ప్రకారం. Constitution, in the Indian Constitution, Part 5, Chapter 4, Union Judiciary, according to Article 145(3), a minimum of 5 judges should sit on the bench. A constitutional bench అంటే 5 judges, minimum 5 judges. Remember 145 leads to 5. So section 145 defines that constitutional bench should have at least 5 judges. Five is the minimum number, of course. Deliberate and malicious acts intended to outrage religious feelings by insulting religion or religious beliefs is an offense under Section 295A of IPC, which is equivalent to BNS Section 299. IPC of offenses relating to religion. That's where we need to look for this one. Section 295, defiling place of worship. Section 295A deals with the deliberate acts or malicious outrage of religious feelings, same as in Section 299 of BNS. So, navigation. The A inserted section is the deliberate and malicious one. So, A also gives you the clue that it is an amended part. Under which CRPC provision can a citizen move a magistrate on a matter of public interest, public nuisance / conditional order? So, under Section 133, B is the right choice. We can a citizen can move a magistrate. CRPC Section 133 equivalent to Section 152 of BNSS, magistrate's conditional order for removal of public nuisance. Section 144, urgent orders. So how we find maintenance of public order and tranquility chapter in CRPC. They deal with old CRPC Section 144. Under the new law equivalent sections, we can see Section 133. Suits by indigent persons are dealt with under. Indigent persons ante those who cannot pay court fee. They're poor, but they have a grievance. When they approach the court, first they need to figure out, they need to apply to be declared as indigent, and then accordingly the further orders and rules will apply. Suits by indigent persons, formerly paupers, order 44th, which is equivalent to appeals by indigent persons. So special category suits live in the higher numbered orders. Special category suits live in the higher numbered orders. In here it is CPC order 33rd. 33. Under which provision may a dying declaration be admitted in evidence? It is related to Evidence Act, Bharatiya Sakshya Adhiniyam. You will find suitable sections, similar sections. Section 32 of Indian Evidence Act or Section 26 of BSA. It is an exception to the hearsay rule. Navigation. Statements by persons who cannot be called as witness under relevancy. So, we generally call it as dying declaration, generally done by people who are about to die in a very grave and serious condition. Most probably they will not survive. So such people, whatever declarations they make, we can take it as an evidence. The courts will consider that as an evidence. Which section of the Muslim Personal Law, Sharia, Application Act 1937 was amended by Section 6 of the Dissolution of Muslim Marriage Act in 1939. Section 5. Dissolution of Muslim Marriage Act 1939, Section 6 repealed Section 5 of the Sharia Act 1937, which had dealt with a dissolution by a woman. So, a later act's repeal amendment clause is usually its penultimate section. penultimate section. When section 5 is repealed, you are likely to see that in section 6. That's the idea. So this comes under broadly family law, specifically Muslim law. The term contract is defined under definition. This is related to definition. So section 2H of the Indian Contract Act 1872. Whenever we are asked to find definition, whenever we need to find definition, in most of the acts, in almost all of the acts, we find them under section 2. So remember, very rarely they are in other sections, but generally section 2 deals with definitions. In this case, the idea of contract is defined under 2H of the Indian Contract Act. So take the Indian Contract Act, Bare Act, go to section 2. Section 2 deals with a lot of definitions and look for contract, and that's where it is defined in 2H. Indira Sani versus Union of India is popularly known as Indira Sani. See, remember always, it's somebody against the Union of India. So that is probably it's initiated by a citizen. So here Indira Sani initiated something, and that is popularly known as Mandal Commission case. Indira Sani 1992 upheld 27% of OBC reservation and the 50% ceiling. The Mandal case. Build a case nickname, flashcard set, Keshwananda, basic structure, SP Gupta, judges transfer case, Maneke Gandhi, due process. So this is one way to be prepared for the exam. All major cases we should be able to, all major constitutional cases especially, we need to remember. Under the Bharatiya Nyaya Sanhita, force amounts to criminal force. When? What is the difference between force and criminal force? It is used intentionally without consent, causing injury, fear, or annoyance. That means when the force is really to affect either injury or fear or annoyance, then that force will be considered as a criminal force. So chapter on criminal force and assault deals with these terms in Bharatiya Nyaya Sanhita. The qualifier is intentional use without consent. So when you find such phrases, it's obviously in the criminal sense. Which provision prescribes the procedure for a magistrate to record confessions and statements? Section 164. CRPC section 164, which is also equivalent to section 183 of BNSS, recording of confessions, statements by a magistrate. So, contrast to section 161, police statements, and section 162, their use, navigation, information to police and powers to investigate. That's the chapter we need to look for. So this is all under investigations. So when an order under Order 21st, Rule 46, attracting a debt due to the judgment debtor from a third party is known as attaching a debt due to the judgment debtor from a third party is known as, okay, this is called garnishee order. Garnishee proceedings against a third party debtor. Navigation. Execution machinery is almost entirely in order 21st, probably the largest order in CPC, the biggest. It contains a lot of rules and other standards. So a Garnishi order. Section 110 of the Evidence Act deals with 110. Obviously, this is from Evidence Act or Bharatiya Sakshya Adhiniyam. That's the subject area. Now, burden of proof. Evidence Act deals with 110 deals with burden of proof. Who has to prove it? Who has the ownership to prove this claim? Okay, BSA 110 or 111. Possession raises a presumption of ownership. Burden lies on the one asserting the possessor is not owner. Now, how you navigate? Of the burden of proof chapter, section 101 to 114A. So, obviously, we are talking about 110. First of all, 110, if we look for, it deals with the evidence and it deals with the proof, it deals with the proof of burden of proof, and who has the ownership of proving something. So that's how we need to catch the phrases, catch the important ideas, and look for the sections in the particular act. In case of a if a case is transmitted to the central government under Section 10 of the Special Marriage Act 1954, the marriage must be solemnized within 3 months. Special Marriage Act 1954, Section 10 says 3-month window after the decision. It needs 3-month window after the decision. So, Special Marriages Act, Solemnization of Special Marriages, sections 4 to 13. That's the area we are interested in. Which of the following is not? Not is the operative word here. A negotiable instrument under the Negotiable Instruments Act 1881, which is not a negotiable instrument. A hundi, generally we find it in religious places. Promissory note, bill of exchange, check. It's a hundi. There is no contract in the case of a hundi. So, Negotiable Instruments Act 1881, according to Section 13, which recognizes only promissory notes, bills of exchange, and checks as statutory negotiable instruments. A hundi is negotiable only by the usage or custom. So, Section 13, negotiable instruments, is the closed statutory list. So, there are only 3 things: promissory notes, bill of exchanges, or checks. Which writ is used to compel the performance of a public duty by an authority? The writ of mandamus. Mandamus or mandamus? Mandamus. This is the writ issued by a court to an authority, to an officer or an executive to do what is required of him to be done. So, mandamus means we command. It compels a public duty. Quo warranto, other writs, if we consider, quo warranto, questions say usurper's title to office, certiorari quashes, prohibition forbids, Constitution Article 32 or 226 in the case of High Courts, a 4-line writ table answers robustly. The word injury in the penal code denotes only harm illegally caused to a person. A person's body, mind, reputation, or property. So, if the damage is done to any one of these, body, mind, reputation, or property, it's considered an injury. So, subject area is IPC or BNS. This question appeared in the 14th AIBE. If you look at the right side. Section 6 of the Code of Criminal Procedure, it defines, Section 6 defines classes of criminal codes. See, we said before, generally definitions are found under Section 2 of any act. But then these are different definitions too. These are classifications. So classes of criminal codes is defined in Section 6 of CRPC, also in BNSS. It lists the classes of criminal codes, sessions, magistrates court, courts, etc. How we navigate to get this answer? The constitution of courts. Provisions sit right at the start of the code. Where a decree is passed against the union or state under Section 82 of CPC, execution shall not issue unless the decree remains unsatisfied for 3 months from the date of the decree. CPC Section 82, a 3-month moratorium before execution against government, paired with Section 80, 2-month notice before suit. Okay, navigation. Suits in particular cases, part of the sections. So government is a particular case. So dealing with government, suing government, issuing notices to government, they are all clearly specified under various sections of the CPC. Section 78(2) of the BSA 2023, the presumption regarding an officer signing, certifying a document is that the officer held the official character claimed when signing or certifying the document. That's the assumption. So whoever signs, he has the right, he is in the right place with the right authority to sign a document or certify a document. So the area of subject is the subject is Evidence Act or Bharatiya Sakshya Adhiniyam. Specific topics that we should be looking for is under presumptions as to documents. See, here we have a document, a question of signing, a question of certifying a document. So obviously we should be looking into presumption related to documents. Next question. Iddat under Muslim law refers to. Obviously this is a Muslim law, and iddat seems to be a period where the marriage is in abeyance. Probably the waiting period a woman must observe after divorce or her husband's death before she may remarry. So after divorce or before marrying again, a woman must wait for 3 months. That's called iddat period. It prescribes the waiting period to ascertain pregnancy before mourning or observe mourning. Navigation. For personal law concepts, anchor each term. Under the no-fault liability provision of the Motor Vehicles Act 1988, the fixed compensation payable for death is its no-fault liability. However, the victim is dead. So we need to look under those provisions. So the penalty is 50,000 rupees. It's a fixed compensation, not penalty, fixed compensation. A Motor Vehicle Act 1988, Section 140, original no-fault scheme, 50,000 for death, and 25,000 for permanent disablement. Later structured formula provisions exist. Navigation liability without fault sections in Motor Vehicle Act. So that's how from the question we need to figure out which section is likely to contain the answer we are looking for in that act. Section 70 of the Indian Contract Act. So we are dealing with Indian Contract Act, and we also know that it is section 70. So benefit of a non-gratuitous act embodies the principle of. So it becomes very easy because we have the bare act, Contract Act. You turn to section 70 and then it embodies. It talks about what? It talks about quantum merit. So one who enjoys the benefit of a lawful non-gratuitous act must compensate. Recovery is on a quantum merit basis of certain relations resembling those created by contract. Section 68 and 68 to 72 deal with this issue. The fundamental rights. So we are dealing with constitutional law. Are guaranteed under which part of the Constitution of India? Now we are dealing with the parts. So Constitution, the fundamental rights are in part 3. So that's how we need to remember. Not remember or look up to. Look up in the bare act, in the constitutional law book. Memorize the part map of the Constitution. Part 3 deals with fundamental rights. Part 4 deals with directive principles. Part 4A deals with fundamental duties. Open the Constitution Index and jump to Part 3 for any fundamental rights question. It's that simple. So we have fundamental rights, we have directive principles, and then fundamental duties. The right of private defense of property extends to voluntarily causing death of the wrongdoer in which of these offences? Robbery, the housebreaking, after sunset, and before sunrise. So in these cases, in protecting yourself, if you hit the offender and if the offender dies, that also comes under right of private defense. If the offender gets grievously hurt or dies, it all falls under right of private defense. So you have the right to appeal for private defense. BNS 2023, right of private defense of property, old IPC section 103. A police officer may carry out a personal search of an arrested person under section 51 of CRPC. So take CRPC because all the choices are from CRPC. Take CRPC. All the choices are consecutive sections. So go to section 49, then 50, then 51, then 52. You should see the word arrest and search, personal search. So section 51 CRPC is the correct choice here. So section 50 deals with the grounds of arrest, right to bail information. Section 49, no unnecessary restraint. So these all, like when somebody is arrested, the things involved with the arrest. If a party granted leave to amend its pleadings does not amend within the time fixed, that is 14 days, it shall not amend later without leave. The default period is 14 days. CPC Order 6th Rule 18, failure to amend within the time limited by the order or within 14 days, navigation, amendment of pleadings Order 6th, Rule 17, power, and Rule 18, failure to amend. So this is all procedural in civil matters. So go to CPC, go to Order 6, Rule number 17 deals with power and 18 deals with failure to amend. So in this case 14 days, B is the correct choice. Under which provision are admissions defined? Admissions, automatically we need to look up in Sakshya Adhiniyam or Evidence Act. So under section 17 or section 15 BSA. 17 defines admissions in IEA. In BSA, section 15 read with section 18 to 23, who may make when relevant, things like that. So admissions immediately follows the relevancy of facts sections. Absent contrary agreement, arbitral proceedings commence. Section 21, Arbitration Conciliation Act 1996. Absent contrary agreement, arbitral proceedings commence. On the date the request for the dispute to be referred is received by the respondent. On the date. So Arbitration Conciliation Act 1996, Section 21, it defines with this concept. So the commencement marker matters for limitation. Locate Section 21 in the Conduct of Arbitral Proceedings chapter. On which date did the Hindu Marriage Act 1955 come into operation? So all the major acts in our subject, in our syllabus, we should identify the act, the year it was enacted in, and the specific date that came into effect. So 18th May 1955, the Hindu Marriage Act 1955 came into effect, came into operation. So every act, the date of the act is different from the date of implementation of that act, the date of operation of that act. Enforcement on 18th May 1955. Commencement clauses are in the section 1 of the act. Under which provision can a public interest litigation be filed directly in the Supreme Court? Supreme Court, according to Article 32. So if you are filing a bill in higher court, in High Court, then Article 226 provides for that. So Article 32 in the case of Supreme Courts, Article 226 in the case of High Courts. Directly in the Supreme Court points to Article 32, right to constitutional remedies, navigation, pill questions resolved to writ jurisdictions. Pill questions resolved to the writ jurisdictions. The writ jurisdictions are specified in 32, Article 32, related to Supreme Court matters, or 226 in matters related to High Court. Which provision of the Advocates Act 1961 empowers the Bar Council of India to prescribe standards of professional conduct and etiquette? Section 49. It deals with the conduct of the advocates as well as the allowed etiquette, the way we dress, the way we show up in the court, the way we speak, the way we stand, our body language, all sorts of things can be specified, and Bar Council of India has the authority as per Section 49 of the Indian Advocates Act 1961 to do so. Powers of BCI section cluster in the 40s, Section 40 and beyond. So 49(1)(c) deals with conduct and etiquette. Section 2(q) of the Industrial Disputes Act 1947 defines. So take the bare act, go to section 2, go to 2(q), and then you see strike. Defines strike. So strike, section 2(i), lockout, section 2 KKK, layoff, and a lot of other things are defined there. So go to section 2 and look for 2Q. Clearly it is strike. Very easy questions. The answer itself is in the question. Section 2Q of the Industrial Disputes Act defines. How can we go wrong? It disappeared on the 11th AIBE. So we should always look for such easy questions, and we can do it under 10-20 seconds. In MC Mehta versus Union of India, popularly known as oleum gas leak case, 1987, the Supreme Court evolved the principles of, or the doctrine of, sometimes they say the doctrine of, the principle of. So it's absolute liability, no exceptions, unlike strict liability. MC Mehta carved out absolute liability for enterprises in hazardous activity. None of the Ryland's exceptions apply. The damages correlate to the enterprise's capacity and how we navigate. We go through contrast Ryland's strict with exceptions versus MC Mehta absolute. Under Article 279A, the GST Council is constituted by, so it's law related to taxation, obviously, goods and services tax. And here, GST Council is constituted by. Who constitutes this council? A collective body of the union and the state. It's a collective body and drawing representatives from the union as proposed by union government and the states. A federal body, union finance minister as chair, plus state finance ministers as members. Navigation. Article 279A sits with GST articles 246A, 269A introduced by the 101st Amendment Act. A contract of indemnity is defined under. Indemnity deals matters, it shows up in insurance. So section 124 of the Indian Contract Act deals with a contract of indemnity. Indian Contract Act section 124 indemnity, 126 guarantee, 128 sureties liability, and so on and so forth. How we go there, how we navigate ourselves. Take Indian contracts, go to indemnity and guarantee chapter. Section 124 deals with indemnity and 126 deals with guarantee. And there is the distinction if you want to see the difference also. So we are interested in indemnity. Section 124 deals with indemnity. Which article is relevant for resolving repugnancy between a central law and a state law on a concurrent list subject? We know we have 3 lists identified, one for the union government, union list, 2 for the states, and 3 the concurrent. Article 254, Part 9 of the Constitution, relations between Union and States. No, Part 11th of the Constitution, relations between Union and States. Legislative relations, Article 254. Inconsistency between laws made by the Parliament and by state legislatures. A mnemonic, repugnancy, 254. Article 254 deals with repugnancy. A is at work with a hatchet. The head flies off and kills a bystander. A is not guilty, the act being an accident without criminal intent or knowledge. So, Section 80 checklist. Lawful act plus lawful manner plus proper care plus no mens rea, no ill intention. So all these things make it not a crime. So A is not guilty. So we find these things under general exceptions of BNS and IPC as well. The duty of the police to forward a report, charge sheet, on completion of investigation is contained in. So once the investigation is done, the police must forward a report, which we generally call it a charge sheet. Section 173 2I of CRPC prescribes this. A report of police officer on completion of investigation, according to section 173 2I, lists what the report must state. How we navigate? Investigation chapter, the closing report section. So this is from CRPC BNSS. AIBE 14th asked this question. Section 88, read with order 35th CPC, deals with. Section 88, read with order 35th of CPC, deals with interpleader suit. These are special suits. CPC section 88 plus order 35th, interpleader suit, where the defendant claims no interest but rival claimants do. No claims, no interest but rival claimants do. Navigation. Match the section to its order. Section 88 and order 35th. Leading questions may be asked in. So if you look into examination of witnesses, when we cross-examine, in the case of cross-examination, leading questions may be asked. Leading questions are permitted in cross-examination, in chief and re-examination only with the court's permission, or on undisputed introductory matters. Navigation of the examination of witnesses chapter of the Evidence Act. Statement 1. An arbitration agreement must be in writing. Contracts, letters, telex, telegrams, electronic communications. Okay. Then statement 2. It may be implied solely from conduct without any written record, which is correct. Only statement 1 is correct. Arbitration Conciliation Act 1996, Section 7, the agreement must be in writing. Section 7(4) lists the written forms. Pure oral conduct-based agreements do not qualify for arbitration or do not qualify as contracts. Section 7 arbitration agreement, as per Section 7, arbitration agreements are defined. Under the Hindu Succession Act 1956, as amended in 2005, a daughter in a coparcenary becomes a coparcener by birth in her own right, like a son. So, Hindu Succession Act Section 6, post 2005 amendment, confirmed in Vinita Sharma versus Rakesh Sharma 2020. The daughter is a coparcener by birth, irrespective of the father being alive in 2005 or not. Navigation. Hindu Succession Act Section 6, devolution of interest in coparcenary property. Who and how share a property under coparcenary situation? Which of the following is not a genuine purpose of public interest litigation? Which of the following is not a genuine purpose? You don't want to go for pill. Where? In getting publicity and in making personal wealth. So, vindication of the rule of law, yes, you can go and file a pill. Getting publicity and making personal wealth, nope, you cannot do pill. Through pills you cannot gain publicity. Effective access to justice, yes. Meaningful realization of fundamental rights, yes, you should file pill where necessary, but not to get publicity, not to just make personal wealth. The spirit of PIL, public interest litigation, is strictly limited to the interests of the public at large. The maxim Adi alterum partem means, it's a Latin maxim, Adi alterum partem. See, audio, something related to listening, hearing. So obviously this doctrine tells us that hear the other person. No person shall be condemned unheard. Without without asking for the explanation, you should not condemn anybody. You cannot punish anybody. Audi alterum partem, hear the other side. And nemo judex in causa sua. No one shall be a judge in his own cause, are the twin pillars of natural justice. Keep the two maxims paid in memory. So, when one is asked, the other is likely to be asked. Both of them stand up to the cause of natural justice. Which statement is incorrect under the Bar Council of India rules? Incorrect. An advocate may plead in a matter in which he is himself probably interested. So, he should not be. He should not be representing himself. So, this is incorrect. BCA Rules Part 6, Chapter 2, bar an advocate from acting, pleading, where personally, pecuniarily interested. Whether he is personally interested in the matter or he is to gain wealth, he is interested in that matter. So, duty to the court, to the client rules. The prohibited conduct is the odd one out. So, choice is incorrect. Next question. The minimum number of members required for the registration of a trade union is 7. In the case of trade union, to register a trade union, you should have at least 7 members to start with to register the trade union. Trade Unions Act 1926, Section 4, according to Section 4, only 7 or more members may apply for registration, and at least 10% or 100, whichever is less, must remain. Navigation. Registration chapter, the threshold section. So to register you need 7 and at least 10% or 100 at any given time. To maintain the trade union, you should at least have 10% or 100, whichever is less. And the rule of last opportunity was laid down in last opportunity. This is a law of tort. Okay, Davies versus Mann. Davies versus Mann, 1842. The party with the least opportunity to avoid the accident is liable. Contributory negligence doctrine. Contributory negligence plus last opportunity cases form a small high yield set. Last opportunity, LAST, last opportunity. GST provisions were inserted into the Constitution by GST. The GST provisions were inserted into the Constitution by the Constitution 101st Amendment Act 2016. In this amendment inserted Article 246A, 269A and 279A for GST Council. Keep 101st for GST on your amendments chart alongside the GST Council Article 279A. So just to remember, you prepare a list of important things, important amendments, important acts, important sections, important items, looking for when we are interested in their definitions. So we should prepare a small sheet for quick reference. Regarding declaratory decrees under the Specific Relief Act 1963, declaratory decrees. Okay. So Section 34 deals with it, and it is discretionary in nature. Both Section 34 deals with it, and it is discretionary in nature. Specific Relief Act Section 34, according to the Section 34, declaration of status or rights. Section 34 effect. The remedy is discretionary. How we navigate? Declaratory decrees chapter, sections 34 to 35. So first, for any question, we need to identify the act and the concept, and then go to the concerned chapter. Within that chapter, we are likely to find the section very easily. The title, short title of the Constitution of India is laid down in which article? Article 393. Navigate the bare act backwards. The very last provisions carry the short title commencement. Okay, this is a clue. This is the strategy. Every act go to the last provisions. The very last provisions carry the short title or commencement dates. Constitution, Part 12, short title, commencement. Article 393 declares. Next question. Under the Bharatiya Nyaya Sanhita 2023, the maximum number of consecutive days an offender may be kept in solitary confinement at one time is solitary confinement. Nobody else will be there. He cannot see anybody. He cannot interact with anybody. he'll be isolated pretty much from other humans, human interactions. So at a time, you cannot keep anybody in solitary confinement for more than 14 days. BNS 223 limits on solitary confinement. Old IPC 73 to 74. A single spell cannot exceed 14 days. Total is capped by reference to the sentence length. Where to find, how to find. BNS of punishments chapter. Then look for solitary confinement. Plea bargaining is available only for the offences punishable with imprisonment up to. Plea bargaining is not available for everybody. If the crime, if the allegation involves a punishable offence with imprisonment up to 7 years, then plea bargaining is available. CRPC chapter 21A, sections 265A and 265L, 265A to 265L, BNSS chapter 23rd, plea bargaining excluded where punishment exceeds 7 years. Or for offences against women, children, or socio-economic offences. The threshold is an opening section of the plea bargaining. Under order the 4th, Rule 1, a plaint must be presented to the court in a plaint. Duplicate. One stays with the court and the other will be sent to the respondent. So CPC Order 4th, Rule 1, every suit instituted by presenting a plaint in duplicate navigation orders the first schedule are separate from the sections for how to file. Go to order the 4th, order 6th to 7th. So these are the matters related to pleadings. The 16th AIBE asked for this. Under section 46 of the Bharatiya Sakshya Adhiniyam 2023, character evidence in civil case is relevant only when it relates to some other relevant fact. According to section 46 of BSA, in civil cases, character is generally irrelevant unless it bears on a fact otherwise an issue relevant. Navigation. Relevancy of character sections, civil versus criminal rules differ. Which of these orders is not appealable under the Arbitration and Conciliation Act 1996? Not appealable. Refusing to appoint an arbitrator under section 11. Appealable orders are listed in section 37 and section 50. Section 11, appointment orders are dealt with separately and are not in the 37th section list. Navigation. Read section 37 as a closed list. If it is not there, it's not appealable. A petition to annul అంటే void చేయటం. Annul a marriage for fraud under the Special Marriage Act will not be entertained if The petitioner lived with the respondent as husband and wife after discovering the fraud. Cohabitation with full knowledge of the fraud bars annulment. Navigation. Nullity of marriage and divorce part. Read the section together with its provisions. Which bill expanded Article 21 to include the right to enjoyment of pollution-free water and air? Subhash Kumar versus State of Bihar, 1991. Subhash Kumar Article 21 expansion cases. Olga Tellis, livelihood. Subhash Kumar, clean environment, and Hussain Ara, speedy trial. So these are the things under Environmental Protection Act. Public interest litigations. Which best defines delegated legislation? Defines. So somewhere in some definition section we find this. Delegated legislation. So this is about delegation. So it falls under administrative law. Go look for administrative law. In administrative law, under delegated legislation. Delegated or subordinated legislation, same as rules, regulations made by the executive under a parent statute. So identify a parent act plus enabling section for any rule. Laws made by an administrative authority under powers conferred by Parliament. So generally when the act is made, rules are made by the state legislature or the executive, but in most of the cases the regulations are made by the executive. The appellate authority against an order of the disciplinary committee of the Bar Council of India is the Supreme Court of India. So if there is a dispute about the decision of a disciplinary committee of a state bar council, then you can appeal in the Bar Council of India. But if you want to make an appeal on a disciplinary committee's decision of the Bar Council of India, then you go to the Supreme Court to appeal. The doctrine of lifting or piercing the corporate veil is associated with company law. The doctrine of lifting the corporate veil, lifting or piercing of the corporate veil, is associated with the company law. Solomon versus Solomon and Company Limited established separate legal personality. Courts lift the veil to reach the persons behind a company in fraud or sham cases. Navigation. Link the doctrine to section 220, company, and the separate personality principle. The Water Prevention and Control of Pollution Act 1974 chiefly regulates. What is that this act regulates? the discharge of pollutants into the nation's water bodies. Water Act 1974 governs prevention and control of water pollution, boards, consents, effluent standards. So air pollution, Air Act 1981, navigation, name of the act tells you the medium it regulates. So if there is a question on air pollution, go to Air Act 1981. If there is a question on polluting water, go to the Water Act 1974 and so on. Under the IT Act 2000, the person intended by the originator to receive an electronic record is the addressee. Under the IT Act 2000, the person intended by the originator to receive an electronic record is the addressee. IT Act 2000, Section 21B, addressee versus Section 21ZA, originator versus Section 21W, intermediary. So these are the three things defining addressee, originator, and intermediary. The definition section S2 carries all these. Under Section 23 of the Employees Workmen's Compensation Act 1923, the Commissioner has the powers of a civil court. A civil court. So go to Commissioner's chapter, Powers and Procedures section, and we will find the Commissioner has the power of something like a civil court. The Central Consumer Protection Council under Section 3(2) of the Consumer Protection Act of 2019 consists of the Central Consumer Protection Council. Council is a body. Okay, it consists of a chairperson and such other members as may be prescribed. Okay, the 2019 Act replaced by the 1986 Act replaced the 1986 Act. So 2019 is the latest. For councils and authorities, read Section 3 of CCPC and Section 10 of CCPA. Under the Income Tax Act 1961, a 30% standard deductions of annual value is allowed for house property. Then statement 2 is, interest on the borrowed capital for a self-occupied house is capped at rupees 2 lakhs, which is correct. Both statements are true. Income Tax Act 1961, Section 24 and Section 24A, standard deductions 30% of NAV. Section 24B, interest deduction capped at 2 lakh rupees for self-occupied property. So how we navigate to this? Go to income and house property, income from house property head under Section 22 to 27. A check is returned for insufficient funds. Within what period must the payee make the written complaint? within 1 month of the cause of action after the 15-day notice. Negotiable Instruments Act 1881, Section 138 and Section 142 serve demand notice within 30 days of dishonor. If unpaid in 15 days, file the complaint within 1 month character. Navigation read Section 138 offense/conditions with Section 142, which is cognizance and limitation. So a check is returned for insufficient funds. Within what period must the payee must? Okay. Under the RFCT LARR, popularly known as the Land Acquisition Act of 2013, if no award is made within how long from publication of the declaration, the entire acquisition proceedings lapse. Once the declaration is published, you cannot wait for more than 12 months. So within 12 months it should be done. Otherwise it becomes lapse. So RFCT LARR Act 2013, Section 25, award within 12 months of the declaration as per Section 19, else proceedings lapse. Navigation, process flow, preliminary notification Section 11, declaration Section 19, and award Section 23 within 12 months from the date of filing. Under the Parents Act 1970, which of the following is not patentable? Not patentable. A method of agriculture or horticulture, a mere presentation of information, the topography of integrated circuits, all of these. The concept of freedom of trade, commerce, and intercourse in the Indian Constitution is borrowed from the experience of which country? Australia. The concept of freedom of trade, commerce, and intercourse. Australia. Constitution, Part 8, Articles 301 to 307 is modelled on the Australian Constitution, Section 92. Keep a borrowed features chart. Directive Principles of State Policy from Ireland. Fundamental Rights and Judicial Review from United States. Parliamentary System, UK. Trade and Commerce, Australia. So we adapted or we borrowed ideas from UK, USA, Australia, and Ireland. Voluntarily throwing an attempt or attempting to throw acid is an offence punishable under, so popularly known as acid attacks. These are offences punishable under Section 326B of IPC. Equivalent section BNS is Section 124(2). Which provision of the CRPC deals with anticipatory bail? So we should look under bail. of CRPC. So take the bare act CRPC, look for the keyword. Which provision of the CRPC deals with the anticipatory bail? Section 438, anticipatory bail. In BNSS it is 482. Group the bail family of sections. For example, 436 bailable, 437 non-bailable, 438 anticipatory, 439 sessions or High Court special powers. Provisions regarding the filing of suits by an alien under the CPC are dealt with under Section 83 of CPC, Code of Civil Procedures. All these things fall under jurisdiction. Section 83, when aliens may sue, read with Section 84 to 87A on suits by or against foreign states, rulers. So how should we navigate? Go to suits in particular cases, sections 79 to 93. So in this case, Section 83 deals with suits by an alien. Alien is somebody who is not Indian citizen or Indian company. As to proof of contents of documents, the correct statement is: contents may be provided by primary or by secondary evidence. Secondary only in cases the law permits. Okay, Indian Evidence Law 61 to 65 or BSA 56 to 60. Primary evidence is the rule. Secondary is allowed only in the listed situations as per Section 65. So how do we navigate to this? Documentary evidence chapter, read Section 61, modes before 65 when secondary is allowed. So here the answer, the right choice is B. Contents may be provided by primary or by secondary evidence. Which of the following is a characteristic of mediation? So this is under Administrative Dispute Redressal, ADRs. A neutral third party facilitates negotiation between the parties. So that's called mediation. Mediation is equal to facilitative, non-binding, the Mediation Act of 2023. Distinguish arbitration. Arbitration is binding award, and conciliation, navigation ante how to navigate to these. Compare the 4 ADR modes on a single grid. Who decides is it binding or not? So in this case, which of the following is a characteristic of mediation? Mediation is one of the ADR techniques. A neutral third party facilitates navigation between two parties. It's not binding. The next question. The maximum term of imprisonment under Section 31 of the Protection of Women from Domestic Violence Act 2005 for breach of a protection order is: maximum term of imprisonment is 1 year. So, Protection of Women from Domestic Violence Act 2005, Section 31, breach of protection order up to 1 year and or a fine of up to 20,000 rupees. So the penalty section sits in the offences and penalties part of the Act. So, in family law, go to domestic violence, and then matters related to domestic violence are covered here. SP Gupta versus Union of India 1981 is decided primarily on judges transfer and liberalization of locus standi. So this is popularly known as, this particular case, the judges transfer case, SP Gupta versus Union of India. This is when the rules for locus standi are relaxed by Justice Bhagavati, P.N. Bhagavati. Any public spirited persons to file pills, how to navigate, tie each early pill case to the doctrine it expanded. So we identify maybe 5 to 10 popular pills and what the issue was and how the courts ruled and what doctrines or principles are established, what guidelines are issued. I think that all that should be in one place as a ready reference for our exam purpose. Which writ is issued against the usurpation of a public office? Writ of quo warranto. Quo warranto is by what authority? Challenges a person's title to a public office. How we navigate? Match writ to function. So writs are part of administrative law. Go to administrative law, look up for writs, and we have mandamus, which calls for public duty, certiorari, quashing, prohibition, prevention, quo warranto, with what authority, related to somebody occupying without proper authority a public office. Next, proceedings in cases of professional misconduct are. Proceedings in cases of professional misconduct, professional ethics, and we say rules, nature of proceedings. They are quasi-criminal in nature. Disciplinary proceedings under the Advocates Act are quasi-criminal. Standard of proof is high, though the forum is domestic. Navigation. Section 35, punishment of advocates for misconduct plus case law on the standard of proof. Together, if we see, it is proceeding, these type of proceedings are considered quasi-criminal in nature. A private company converting itself into a public company must alter its memorandum of articles and articles of association by passing a dash special resolution. Companies Act 2013, Section 13 and 14, alteration of MOA AOA requires a special resolution. 75% of the board should agree for that. Navigation, incorporation and alteration, chapter conversion is equal to special resolution. Conversion calls for special resolution. So when a private company wants to convert itself into a public company, at least 75% of the board should resolve in favor of that. Which fundamental duty relates to environmental protection? Fundamental duty. We have fundamental rights, we have directive principles, and we have fundamental duties. So Article 51A G deals with fundamental duty to protect environment. Constitution Part 4A, Article 51A G prescribes that duty to protect and improve the natural environment. Navigation. Keep the lettered subclauses of Article 51A handy. G. Environment. K. Education of a child. 51A. An attempt to acquire sensitive information like usernames, passwords, card details, by masquerading as a trustworthy entity in an electronic communication is known as phishing. Phishing, 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 deceptive lure via email, websites, forming, redirecting to fake sites, smishing via SMS. How we navigate? Go to IT Act 2000, refer to offences, Section 66C, identity theft, Section 66D, cheating by impersonation, plus the standard cybercrime taxonomy. So if we are familiar with all those things, we know the difference between phishing and smishing. The objective of the Industrial Disputes Act 1947 is Industrial Disputes Act 1947 is to secure industrial peace and economic justice, harmonious relations, and prevention of illegal strikes, lockouts. So Industrial Disputes Act 1947, investigation and settlement of industrial disputes. Its objects cover all the listed aims. How we navigate? Read the preamble plus statement of objects for purpose question. The objective, statement of objects. The rule of strict liability is based on the decision in the rule of strict liability, Rylance versus Fleischer in 1869, established strict liability. Liability without fault for the escape of a dangerous thing brought onto land in a non-natural use. Donahue versus Stevenson, negligence or duty of care. Navigation, tag each leading case to its tort doctrine. Tort doctrine. Here the tort doctrine is strict liability. Law of torts and other acts. Strict liability explains what it is. The definition of money under GST law does not include currency held for its numismatic value. Some people collect stamps, some people collect coins, currency, notes, etc. So if anybody saves them for future value, not necessarily for its current value, as a collectible, then such currency notes are not considered money. So the definition of money under GST law does not include currency, either coins or notes held for its numismatic value. Collector's items. Frustration of contract, supervening impossibility is provided under. So though it is contracted, you cannot expect an impossible thing to be done. So that's considered under frustration of contract. Section 56 of the Indian Contract Act. Agreement to do an impossible, unlawful act is void. Supervening impossibility discharges. Navigation, contingent contracts or contract performance sections. That part of the Indian Contract Act deals with the doctrine of frustration, Section 56. Section 56 of the Indian Contract Act. Frustration means something impossible, something unlawful, though contracted, is void. Minimum percentage of affected families whose prior consent is required for acquiring land for private companies under the RFCT LARR, the Land Acquisition Act 2013. In case of private companies, it's 80%. 80% consent for private projects, 70% for PPP, public-private partnership projects. So go to consent section, consent provisions in section 2.2. Remember the 80-70 split. 80 for private, 70 for PPP. That's the percentage of affected families whose prior consent is required. Who is the registrar? Registrar of trademarks for the purposes of the Trademarks Act 1999. The Controller General of Patents, Designs and Trademarks. Trademarks Act 1999, as per section 3, the Controller General of Patents, Designs and Trademarks is a registrar. So how we navigate to this? The same officer heads patents, designs and trademarks. Copyright also has a separate registrar. So designs and trademarks. The copyright has a different registrar. So the Controller General of Patents do not deal with copyright issues. So with that, this mock test is complete. But going forward on the real test, on the real exam, please attempt everything. Do not leave any question blank. And you win on navigation. You try to understand which act, what is the issue at hand, what section probably deals with it. So once you have a vague idea of the act and the topic that you are interested in, you will find the definitions or index of chapters, table of contents of that act, leading you to the particular chapter or particular section that you are interested in. Master the new codes, obviously, and drill the recurring set. Recurring set is frequently asked questions like what's the bail, what is bailable, what is in what cases you get a bail, you do not get a bail, what is anticipatory bail, and who can issue what type of relief, things like that. I think these are very repeated questions and we should be familiar with. Wish you all the best, and I am sure you'll come out with flying colors. Thanks for traveling along. Thanks for using our material provided by Chandu EDU Sphere.